Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. అందరికీ శుభోదయం. ఈ వీడియోలో ఏఆర్ రెహమాన్ గారికి ఢిల్లీ హైకోర్టు 2 కోట్ల రూపాయలు కాపీరైట్ యాక్ట్ కింద అదర్ సైడ్ కాంపెన్సేషన్ కట్టమన్నారు. కానీ ఆర్డర్లో కింద చూస్తే 2 lakhs అని ఉంది. మరి 2 crores 2 lakhs తెలియదు. ఎనివే AR Rahman is directed to pay compensation, temporary compensation as a part of the injunction to pay 2 crores in a copyright case. What is this copyright? AR Rahman, world acclaimed music composer. Justice Pratibha M. Singh of Delhi High Court, in the case of Ustad Fayaz Wasifuddin Dagar. Ustad Fayaz Wasifuddin Dagar versus AR Rahman and others, CSO MM అన్నాడు reference ఏదో 773 by 2023 dated 25/4/2025 directed the Indian music composer AR Rahman to pay 2 crores in a copyright case filed by Ustad Fayaz Wasifuddin Dagar with respect to a musical composition. You know, Copyright Act Section 57 deals with the compensation of the things regarding copyrighted material. So, whenever you are the original owner of the author, original author or original composer of the music, because music is an intellectual property. There may be different ragas, there may be different compositions. If you compose one thing, it is your property. You have got absolute copyright over the same. The dispute arose regarding Shivastuti in the film called as Ponniyin Selvam number 2. Ponniyin Selvam 2. In this case, of course, Mani Ratnam sir was the music composer, whereas Suhasini's husband, AR, he is very famous director. So he was the director. Mani Ratnam is the director for this historical or periodic film, PS2. In this case, the Shivastuti of Ustad Fayaz Wasifuddin Dagar's uncle was repeated, copied, directed to say, as Veera Raja Veera, without obtaining authorization, attribution of moral rights of the original composer. At least Dharmeda, we thank, or this is obtained from Shivastuti of Dagar brothers and Poe, Amad Raila. After coming to know about this, the present plaintiff, who is the uncle, who is the nephew of Dagar brothers, he sent a letter to Mr. Abdul Rahman because he has contacted the singers. The singers are disciples of Dagar brothers. ఏం చేయమంటారంటే అదే సేవలు రిపీట్ చేసామని చెప్పన్నారు. And he sent a letter. Of course, AR Rahman has to, whether willingly or unwillingly, he has to attribute or he has to acknowledge the same. And ultimately, the main point is Mr. Rahman did not give any recognition to the work of Dagar brothers initially. He reluctantly acknowledged, but the case is going on. Right? And incidentally, the persons who sang the song are the disciples of Dagar brothers. Right? Now, the Honorable Court, Delhi High Court said, right to paternity and right to integrity are the recognized morals in a copyright as per Copyright Act 1957, because there may be so many shlokas, there may be so many ragas, there may be so many compositions, but Dagar brothers, they are slated to be the first copyright owners. It is a traditional work, it is a traditional creature, it is a creative work of the composer Therefore, he is entitled under section 57. Each composition would be original so long as they are prima facie having separate composition. రాగము, చరణము, పల్లవి నాకు పెద్దగా రాదు కానీ బట్ డెఫినెట్లీ ఒక రాగాన్ని ఒక్కో రకంగా తీసుకెళ్తారు కొంతమంది, దాన్ని కాపీ చేయడానికి లేదు అనేటువంటిది ప్రైమా ఫేసి ఇట్ ఈస్ ఎస్టాబ్లిష్డ్ దట్ డాగర్ బ్రదర్స్ దే ఆర్ ది ఓనర్స్ ఆఫ్ ద కంపోజిషన్. అట్లీస్ట్ ఏఆర్ రెహమాన్ షుడ్ హ్యావ్ అక్నాలెడ్జ్డ్ దిస్ ఈజ్, ఎందుకంటే మొదట్లో పలానా వాళ్ళకి ఏదో అభినందనలతోనో ఏదైనా చెప్పింటే పోయేది, అది కూడా రాయలా. అండ్ నౌ హీ హ్యాస్ టు పే 2 lakhs యాజ్ కాంపెన్సేషన్ temporarily, and he has to acknowledge the same on all the OTT platforms. So therefore, interim injunction is granted on Order 39. Anyway, temporary relief was also given to the so-called plaintiff, that is nephew of Dagar brothers. I did not expect AR Rahman, but anyway, ఇది కరెక్టో కాదో మనకు తెలియదు కానీ, బట్ anyway కోర్టులో వచ్చింది, కోర్టు దాకా టెంపరీ ఇంజెక్షన్ ఇచ్చింది కాబట్టి ఈ కేసు మీకు చెప్పడం జరిగింది. ఓకే, విత్ దిస్ ఐఎమ్ కంక్లూడింగ్. థ్యాంక్ యూ వెరీ మచ్.